Good afternoon, my name is Alena Shautsova. I'm an immigration attorney from Brooklyn, New York. In today's video, I would like to talk about recent changes to asylum law. Again, the United States government is changing the standards as to how one may qualify for asylum in the United States. And these particular changes will mostly affect those who are going to be seeking what's called credible fear interview. Usually, these are the people who are coming to the United States and are requesting asylum at the port of entry. Perhaps they landed on the United States territory pursuant to a visa, they had a visa, and now they're questioned by CBP officers. They're told that they will be removed out of the United States, and the person says, well, wait a second, I also have a fear of being sent back because I have asylum claim, valid asylum claim, right? Or perhaps it's a person who is approaching the point of port of entry and is subject to expedited removal because he or she does not have a visa at all, but presents a claim for asylum or claim for relief under Convention Against Torture. So what's happening with that? What's happening is that the United States government says that they're proposing new bar to asylum. A bar is something that will disqualify a person from receiving asylum if the person is found to be subject to the bar. And guess on what that new bar is based? It's based on COVID-19. Specifically, the government says that if a person presents risk of bringing in deadly infectious or risk of further spreading infectious, he or she will be found ineligible for asylum. Thus, he or she will be found as to fail credible fear interview, regardless of whatever else the person is asserting. They say that they will be in grave danger, somebody is after them right behind them, trying to kill them. If they're found to present that risk, they will not be allowed to present their claims further. They will not pass credible fear interview. And I was curious as to how the government is going to determine if the person presents such a risk. And basically, almost any applicant is going to fall under this bar, and be subject to this bar because such a risk, a person will be subject to the bar because of declared public emergency in the United States, for example, conditions in their country, or point of embarkation. Right now, there is a public emergency in the United States. It means basically that everybody presents a risk of spreading the infection, right? Any person potentially may spread the infection. That's how I would look at it, right? So it's a very broad bar that will disqualify people from asylum. What happens is that the government proposes this new rule, gives quite short time to comment on this new rule, I believe for a month, 30 days or so, and then the rule may be in this current version going into effect, or perhaps it will be modified. Also, what happens is that that's not the end of the story. What happens is that before or prior to this new rule, if the person passes credible fear, then as a rule, they would be placed in 240 or regular removal proceedings. In those regular removal proceedings, they may assert other forms of relief, not just asylum, okay? So now they're saying, the government is saying, so even if we find that somehow you passed credible fear interview, we don't have to place you into 40 proceedings. We have a discretion. Or they say that, let's say you didn't pass credible fear in connection with asylum. But then you stated, well, wait, I'm afraid I will be tortured in my country. You, as an applicant, will have to show that you're going to be tortured more likely than not in your country. With asylum, in a credible fear, you have to show that there is a significant possibility that you're going to win your asylum, okay? But for torture, the standard is higher. It's more likely than not. So if you establish that you are more likely than not to be tortured in your home country, the government says they do not have to actually place you in removal proceedings, but they can remove you to the safe third country. It's going to be government discretion what they would like to do. Okay, so that's very interesting point, because there is no denial that there is a prosecutorial discretion. The government has prosecutorial discretion. There is, however, here what I see a bit of a conflict, because if you're saying that a person can come to the border and present all these claims and actually win a very high standard of more likely than not of being tortured, and then the person still is being removed to the third country, wouldn't that mean that the United States effectively is denying protection against for somebody who is alleging torture, right? Because the United States would not consider effectively this person's claim. But that's the proposed rule, and the proposed rule, again, basically no person, according at least to what I read and how I understood it, will be able to prove that they will not be subject to the this bar of possessing danger to the society. And the way, by the way, the logic behind it is that the infectious diseases present national security issue. And traditionally, of course, national security issues were raised in connection, let's say, with terrorism. And now they will be raised in connection with the COVID-19. I have to say, however, that in my understanding and from public information about the COVID-19, even if, let's say, a person is sick, right, at the moment, first of all, the officer is not a doctor to determine that, what specifically they're sick with. But even if they are sick with COVID at the time of the application, why can't they just be isolated or quarantined for a while? I mean, that's number one. Number two, this is a temporary condition, right? We know that in several weeks, the condition will pass. And the problem is that the danger of being tortured will not. And also, of course, the fact that, as we know, protective equipment, at least that's what we're told, reduces the risk of spreading the disease. So unlike certain diseases, and I'm not a doctor, I believe that COVID situation is akin to flu in terms of spreading. But that's where we stand right now. So you need to be aware of that. Potentially this bar, from what I see, can be applied more broadly, maybe perhaps to other proceedings, not just credible fear. We're going to see what's going to happen. Also, I believe that those who are going to challenge the proposed changes may have a very good standing in court for the reasons I just voiced. So that's the news regarding asylum for today. And thank you for watching. Please like, share, subscribe to my channel if you're watching this on YouTube. And I hope to see you soon.